first and foremost, it needs to be appreciated that currently a case is being heard by the division bench of the Delhi High Court, and since the matter is sub judice, I would refrain from commenting on the merits of the case. But having said that, it appears from what's been reported in the public domain that WhatsApp as a service provider is challenging the directions given to it for purposes of identifying the real originator or the first originator of a message. And this obviously is in the context of the power given to the central government under the Information Technology Rules 2021. So the service providers are saying that these rules are prima facie going to be violative of privacy, and therefore that's an argument that they have been putting forward before the court. So we will have to wait and watch what the court ultimately decides, as the matter is sub judice. But clearly this entire issue brings forward the two classical distinctive arguments on two different ends of the spectrum. On the one end of the spectrum is the governments of the world who basically want to know the real identity of the first originator of a message on an encrypted platform, specifically in the light of the fact that this message originator could be engaging in activities which are in violation of the law. On the other end of the spectrum is the argument by service providers who are stating that, look, once we provide end-to-end encryption, we do not even have the intrinsic capability of trying to identify the first originator of a message. And if such kind of an argument or direction is going to be given to the service provider, it will be infringing the privacy of the users. So these are two classical arguments, and I think across the world, the courts will be required to come up with a harmonious balance between these competing two legal interests and come up with an appropriate legal approaches that can be a win-win situation for both the stakeholders.
Another messaging platform is facing a similar scrutiny by the Indian government.
Well, I think what the Indian government is doing is only in accordance with the mandate that's been given under the law. We need to appreciate that in India, the Information Technology Act 2000 is India's mother legislation on everything in the electronic format. So the moment you use a computer system, computer network, computer resource, communication device, as also data and information in the electronic form in India, you get governed by the Indian IT Act of 2000. Now under this law, power has been given to the central government to come up with various rules and regulations to give effect to the provisions of this particular law. It's in this context that the IT Rules 2021 have come across, and this particular provision is mandated therein, where the government can ask any service provider to help identify the identity of the first originator of a message. Now this is not an absolute arbitrary power. This is only to be exercised after due checks and balances, only in matters which are going to be in violation of the law or which could prejudicially impact the security, sovereignty and integrity of the country. But please understand that this direction is going to come from a court order by a court of competent jurisdiction. So the issue is whether service providers will not even follow the mandatory directions given by courts of law, or whether these rules need to be struck aside.
Well, that's complicated, right? Because India is an extremely diverse and large market. For WhatsApp itself, it's the largest market with around 500 million users. So what's the significance that this case is being heard for social media companies in India?
Well, from the perspective of social media companies, this case is important because the directions in this case will ultimately determine how much of encryption is good encryption and how much of the mandatory due diligence will have to be done by service providers when they will come up with encryption services. Well, at the end of the day, when I look at the market, the service providers have the intrinsic capability to go ahead and share information in national interest with the concerned governments or with the concerned courts.
When you say national interest, what is that?
Well, if somebody is working, for example, against the sovereignty, security and integrity of India, the fundamental question is, can he hide behind the cloak of anonymity on WhatsApp or any other social media platform? And the fundamental question is, can the service provider say, sorry, I cannot give you this information because this is end-to-end encrypted? Now
But
clearly,
you understand there is a danger of censorship on social media. If a platform like WhatsApp allows government interference and also dangers to privacy for its users, as WhatsApp has argued.
well, it's absolutely correct, but here it's not a case where the government is asking the information of each and every subscriber. And more so, this information can only be given once an order is passed by a court of competent jurisdiction. So the moment it comes before the judiciary, it is already subject to a layer of judicial scrutiny. Having said that, the judiciary is only going to pass an order for directing the identity of the first originator to be disclosed if it's convinced that it's necessary within the ambit of the provisions of the law. So to give this broad spectrum of the broad brush argument that look, if this is going to lead to violation of all privacy of all users, it does not have any legal foundation. First and foremost, it's only going to be limited to certain cases. That too, it will only be limited to the orders passed by court. Number three, the court will only pass an order once it's satisfied that the mandatory checks and balances and the provisions of the law have been dealt with. And number four, the disclosure of the identity of the first originator in one specific matter which is dealing with violation of the law will have no impact upon the violation or infringement of privacy of lots of other users. So I think somewhere down the line, the service providers will have to realize that if they have to operate in a big jurisdiction like India, they will have to ensure compliance with the law. It's also important to note that a single bench of the Delhi High Court in the landmark judgment of X versus Union of India, where I was the amicus curiae assisting the Delhi High Court, they have categorically upheld the provisions of the IT Rules 2021, though in the context of another matter. So it will be interesting to see how the division bench of the Delhi High Court deals with this entire matter.
But Mr. Duggal, now reports have emerged that WhatsApp has threatened to leave India if it's forced to break its message encryption. And what kind of signal would that send with elections right now happening in the country, with another government which is expected to come in power just in June or July? What do you think is the signal being sent of a social media company like WhatsApp that leaves the country?
Well, we need to quickly appreciate that no company is above the law of the land. If they want to operate in a jurisdiction, one of the fundamental prerequisites is that it will have to comply with the provisions of the prevailing law. If you are not satisfied about a prevailing law, you have the choices to go and challenge the law or its constitutional validity. But
Answer as well, because I know how widespread WhatsApp is.
yeah,
I'm from India, and my family, all of them communicate on WhatsApp. We make international call on WhatsApp. So it is a widely used app. For users as well, it would be definitely an inconvenience, but also the question of trust on this app. If the government is able to get access to the kind of content being shared on it. So it's sort of a double-edged sword.
well, clearly when you read the privacy policy of WhatsApp, you quickly realize that you have hardly any, very little privacy if at all that's available, primarily when you read through the fine print. So the fact of the matter is, we as users need to ask the service providers how much is the encryption that's level. Is it only partial encryption, or is it really end-to-end encryption from the time you create the message till the time the message gets delivered and subsequently? So clearly, people don't need to be very afraid of it, for the very simple reason, not everybody's details are being asked for. Number two, if any service provider feels uncomfortable with the law in India, well, they have the choices to leave the country and leave such a big jurisdiction and the huge market that goes along with it. But to say that, look, I will be in your jurisdiction and will still not comply with the law of the land without even challenging the law of the land is not going to be a legally tenable argument. And therefore, this particular judgment or this particular proceedings will assume more significance.
How could it turn out now? Is there a likelihood that with the past precedents, the court would uphold the law, which is by the government, and what's that mean for the country?
Well, it's very hard for anyone to predict. I'm not an astrologer to predict what the court will say, but I can definitely say that the court is going to be cognizant of all the legal parameters. and the actual ambit of the law before it goes ahead and decides the matter. Of course, courts will obviously try to come up with a harmonious construction of existing provisions of law so that business does not get hampered. But at no point of the time of the proceedings, I expect the courts to say, well, you can continue to flout the prevailing law. Yes, if the courts come to the conclusion that the prevailing law is not in sync with the principles of the Constitution of India, it has got the power to go ahead and strike down the particular provisions of the law as being unconstitutional. But again, that's within the specific purview of the judiciary, and we'll have to wait for how the judiciary comes up and decides this particular matter.